Welcome to the Dawg on It Trucking Podcast. I've got the pleasure of Mr. John Farquhar today from Summit Risk. What is it, John? Summit Risk
Solutions.
Summit Risk Solutions online. And this interview came about because John and I were having a private conversation and he started talking about bills of lading. And it's a subject that I know very little about. So I said, John, could you be my very first guest to do a second interview and discuss bills of lading? Welcome to the Dawg on It Trucking Podcast. When it comes to trucking safety, the Dawg is on it. Well, what do we do on this show? I get to talk to some of the most influential trucking executives in our industry so that we can pick up new tips and tricks to use in our everyday businesses. So with that, let's get on with the show. Mr. John Farquhar, bills of lading. But before we get into that, John, what makes you knowledgeable on bills of lading?
Well, bills of lading are a big interest to me. So when I had my trucks, my fleet back in the 90s, early 2000s, we had our own bill of lading, and it was something that I got into with a customer. So I made a point of educating myself on what I need to know about that bill of lading. And then over the last 15 years of my risk management career with insurance companies, one of the things that we look at is documentation when it comes to cargo and how you're handling and managing that documentation. So I've made a point of educating myself, working with lawyers and industry best practice leaders on what do you need to have in place to cover your butt, or your customer's butt for that matter, when it comes to documentation. So that's how we've kind of gotten into that.
So are you a lawyer?
No.
Okay, so I just wanted to put that out there that we're having this discussion and John is not a lawyer.
This information is more from a high level than it is down here. It's more to intrigue you to look at your bills of lading and ask yourself a lot of questions. And that's where you might want to seek legal advice, legal counsel, to kind of find out, have I got things covered off? But there's a number of things we'll talk about today that can help protect you as a carrier and also help protect your customer in the event of a claim.
So I think that's really good. So the idea then today is to have listeners ask themselves questions.
Yes.
Because you're going to make them think.
Yep. Yeah, and then and if they want to carry that conversation on further, I'm more than open to having some further conversations. We can help them out. We could come in, look at what they're doing, what their practices are, help them out with that, because not so much is it a big issue when you're just hauling some general freight that's worth $10,000. But hey, if we're getting into some high value and some highly attractive cargo for theft, this is where it can be a big concern. If we get into a claim situation, it can cause a great fight between the shipper, the receiver, and the carrier. So these are meant to alleviate those fights, but also to educate.
Right, and your contact information will be in the show notes, or is in the show notes below. So listeners and viewers can reach out and talk to you about bills of lading to stimulate thought and discussion. Yay!
There you go.
All right, so what's the first thing I should know about bills of lading that you would like me to know? Because as I said, I know nothing.
Yep, so probably starting at the basics. So a bill of lading is your contract of carriage, okay? That's the agreement that you have from a shipper or whoever you're hauling the freight for, because sometimes it could be a freight broker. You could be picking it up on behalf of the receiver. So you've got a consignor, a consignee, a shipper, a receiver, you've got a middleman, third party. So a lot of it depends on who you're picking it up for. And then even we're going to confuse it all up and we're going to throw the US in there in a little bit. So, but the concept is the bill of lading is a document that is your contract of carriage. It's the agreement that says, hey, this is what I'm hauling. This is where I'm picking it up. This is where I'm delivering it to. Here's the commodity. Here's how much of the commodity. And it becomes a contract because on a bill of lading, you should have 3 signatures. Shipper, carrier, and the receiver. To make a valid contract, you've got to have all three signatures in there. So, and this is going to be the document that most drivers will pick up when they show up at the shipper's location to pick up the cargo. So one of the interesting things that I find is there's a lot of carriers that don't quite understand the rules and regulations around that. Now, it's become very convenient here in the last 20, 30 years to show up at a shipper and they'll provide you with a bill of lading. Pretty simple. Here it is. Here's the bill of lading. Off you go, driver. Sign your way and away you go. Interesting enough, under the course of the regulation, it's the carrier that is supposed to raise the bill of lading, not the shipper. But the shippers have made it very convenient because of the fact that, well, they've got to have the software to do the packing slip, pro forma invoices, commercial invoices for customs purposes. So the software automatically generates a bill of lading. So it's like, hey, I've got it all for you. Here, driver, just sign this and away you go. The problem with that is, not all, but many shippers, there's no terms and conditions. And they're not on the back of the bill of lading. It might be just like this, blank, And if there are terms and conditions, they're very much swayed towards the shipper's side of the agreement. And the whole concept is it's the carrier's responsibility to put in the terms and conditions of how you're going to transport that cargo. It shouldn't be left to the shipper or the receiver, unless, of course, you have a separate contract agreement above and beyond the bill of lading. So, which is sometimes what you'll see with certain agreements.
All right.
So, go ahead.
John, I got a question though. Is the carrier responsible when the carrier hasn't seen the bill of lading because the driver's signing, not the carrier? The carrier can't be held liable just because the driver signed, can he?
Yes, because they are an extension of the carrier. The driver or operator of the vehicle is an extension of the carrier. So they're fully responsible for who they hire and who they put into that position on behalf of the carrier. So it'll always come back to the carrier. So again, back to some training aspects when you're hiring, of teaching your drivers how to accept the cargo, what to look for on the bill of lading, looking for some key items to make sure that they're there. And if they're not, they should be contacting their dispatch before they leave to be able to go, hey, there's not this, there's not that, or there's this, or, oh my gosh, there's $1 million price tag on this bill of lading. What do I do? So, this is where you need to alert the operations team back at the office to be able to say, here's what's going on. I'm at the shipper. This is what's happening. So,
Okay.
So one of the
Are you going to walk us through what a driver should be looking for?
Yes.
Okay.
Yes, very much so. Yeah. So can I share the screen?
You sure can.
Let's bring up a sample bill of lading. So this is just a sample. This is one of your standard. There are multiples of different bills of ladings and whatnot. This is just a simplistic form, but one of the things that a driver should be looking for, obviously, is completeness. You want to make sure that you've got the consignor in here, point of origin, addresses, dates, any reference numbers, vehicle information if what's required, and then the consignee, where it's delivering to. You've obviously been dispatched to the location to say, hey, you're picking up here in Mississauga and you're heading down to Canton, Ohio. Well, your bill of lading should say it's going to Canton, Ohio, and should have the same information that your dispatch gave you. If not, that should be concerning right off the bat, and questions need to be raised. Same within the body of the goods is we need to have a piece count, what the description of the goods are, weights, stuff along that line. It may or may not have collect prepaid with the freight charges, or it could be a COD shipment. These are some nice to haves. But one thing I want to make sure, preface here, we're not getting into dangerous goods bill of ladings in this conversation. That's a whole nother topic. So we're just going to stick to general freight commodities. So anyway, this bill of lading just happens to have some niceties here for loading time, unloading time. But probably one of the biggest areas that needs to be addressed is right here where it says declared valuation. This is what we see a lot of times not being on the bill of lading, is a declared value. And in absence of a declared value on a shipper issued bill of lading, we usually do not see this disclaimer that says maximum liability shall not exceed $4.41 a kilogram or $2 per pound computed on the total weight of the shipment unless declared valuation states otherwise. So this is a big area that helps the driver to know what's the value of the goods. So we're going to do a little sidestep here. A lot of people between the driver and the carrier will use that concept. Oh, but I have a customs document. I have a pro forma invoice, which has the value on it. I'm okay. No, you're not okay. Pro forma and customs documents are just that, customs documents. They are not part of the contract of carriage. They're not part of the bill of lading, and they're not part of the agreement with the shipment. That is, the pro forma and the customs documents are what the shipper and the receiver or the buyer and the seller have agreed upon on the price of that product. Now, that product could be based on 100 loads, but it's not the value of your load. Your load is not worth 1/100th of that price that they did. Your load is worth what is the value of it today. Because the agreement that the shipper and the receiver or the buyer and the seller put together could have been 5 years ago, and it's taken 5 years to make the product. So they're going to be based on the value that they made the agreement, not today. Exchange rate has a lot to flow into it. Demand, supply and demand. So that can have a bearing on it. So I always encourage clients, do not, and I'll repeat it, do not utilize and rely on the customs document or the pro forma invoice. You need to get from the customer that you're hauling the load for what the true value of that product is. So just to spin it up just a little bit more, every bill of lading should have, as I mentioned earlier, 3 locations to sign. This is what makes a factful and complete contract. Your consignor, your carrier, and your consignee. And every bill of lading should have terms and conditions. This is what you will not find on a regular bill of lading issued by a shipper. So when I had my trucks, one of the things that I did is I worked with my customers and I actually provided them a copy of my bill of lading. I had them printed up in a book form and I would send them out to them and say, here, use my bill of ladings when you're transporting your product on my truck. And we went through this. We talked about what these conditions mean. This is what's going to help protect the carrier as well as protect the customer. And it provides stipulations as to what needs to be done and how it needs to be done in the event of a claim or any kind of issues or anything that's being brought forth.
So how, if I'm asking, I mean, the reason I want to use my bill of lading if I'm a trucking company is because I now know what my drivers are signing. Every time a driver goes out to a shipper and uses a shipper's bill of lading, I as the carrier and that driver as my legal representative committing me to a contract, I don't know what the heck they're signing.
Correct.
So
Correct.
It works in reverse. So how can I get the shipper to use my bill of lading? Because essentially that dock worker who's their representative, they don't know what the heck that dock worker is signing.
Correct. So that becomes the fight that we see on a regular basis, and particularly if you're dealing with a large organization, manufacturing facility, distributor, whatever it be, they've already got their protocols set. So, and especially if you're dealing with a freight broker, freight forwarder, or something along that line, you're into a situation where you're trying to put their customer on the hot seat of using my bill of lading. So that's where we come into a contract, a written agreement that says, hang on, before we haul this shipment, regardless of the bill of lading, let's put a contract in place, and we can stipulate the contract of carriage within the contract. We can stipulate what the value of that product is going to be, what the service agreements are going to be, what the terms and conditions are going to be of me hauling this freight. And then therefore, your bill of lading, when the driver signs it, is a step down from the contract that you have in place. The contract will always supersede the bill of lading. So that will help you to be able to set up that process. Now, a lot of times that becomes another challenge because depending on who you're working with goes, I don't know, I'm not doing no contract and whatnot. But it's all about how do I get the customer to understand this is here to protect you. So let's do another sidestep. So every carrier has to have insurance to operate up and down a road. Every carrier also has to have cargo insurance to haul the product up and down the road. The problem lies in the fact that carriers will get cargo coverages usually for more than what they need, okay, to make sure that they cover themselves. So let's just use an example of Harris Transportation here needs cargo coverage. One of their customers happens to say, hey, you know what, we're going to have some product once in a while. It's going to be worth $300,000. So can you get a policy that has $350,000 worth of coverage and we'll be good? Sure, no problem. So I call my broker, I get my insurance involved, and you know what? We now have a policy with $350,000 worth of coverage. I'll probably hardly ever use it because everything else I haul is maybe $40,000. Okay, so defaulting back to $2 per pound, if the cargo weighs 20,000 pounds, I'm covered for $40,000. If I haul a shipment that is worth $300,000 from ABC Widgets here, but they never put the price on the bill of lading and they never tell me when that price is in place for a shipment, they'll never be covered. They think they are because I have a certificate of insurance that says I got $350,000 worth of cargo coverage. Woo! No. Insurance company's not going to pay out that way. Because if we don't have any agreement in place that says we're going to pay $300,000 for that cargo, but if we never know when it is, how are we going to pay for it? So how it lies in the fact is by having an agreement in place with your customer. So whether it be on the bill of lading and they write $300,000 on that load, the insurance company will cover it because it's been declared on the bill of lading. Or maybe we have a fax or an email confirmation from the shipper saying, hey, Bob, we're going to do that $300,000 shipment this week. It's going out on Thursday. I'm letting you know now that's the load that we need that coverage on. No problem. That email now will help protect you to give you that coverage in place because that's a declaration of $300,000. It's going to be attached with the contract of carriage. So, and like I say, the customs document may never say $300,000 because, well, that wasn't the agreement they made with the buyer back 5-10 years ago. So that's where it needs to be into play now. So we're going to have some fun here, Chris. We're going to go in another direction. So under most understanding within Canada, we have a default of $2 per pound unless a declared value is provided. Okay, that's Canada. Now, but the problem is that is not in all jurisdictions. BC, Saskatchewan, and PEI have a different set of rules. So if you're picking up in that province, you have to apply by their rules, right? So we can all change up the game. So you need to know where you're picking up and what the rules are in that area, in that location. Just because you're from Ontario, but you're picking up in PEI does not mean I can use the rules of Ontario because no, the cargo's originating in PEI. So it's advantageous for a carrier to understand the jurisdictions that they're operating in and where they're picking up cargo coverage, so that they've got the right coverage in place.
John, it's confusing.
Very much so. Very, very much so. It's not cut and dried, and that is a big challenge. So it's trying to, how do I protect myself at all times? And the best thing that I tell customers and clients is have a conversation with your customer. Talk to them about what's the value of the goods. Don't assume, a load of lettuce is only worth $40,000. Do not assume it's worth $40,000. In a time of supply and demand, it may be worth $80,000 or $110,000 because nobody else has got lettuce but this one farmer in California. And guess what? You want it, you're going to pay. So they're going to want full protection on it. So you can't just assume that you know what the value of the goods are. It's have a conversation with your customer and understand what it is that you're carrying and how much it's worth.
Well, the biggest thing I've picked up so far from what you're telling me is I really need to have a contract with my customers.
It's very helpful. Not all customers are going to want to do contracts. Now, on the other hand, there are a lot of customers, your big distribution, I was going to say, just as an example, your Loblaws and your Sobeys, they're the ones that are going to issue you the contract, and they're going to set the terms and conditions. Now, the thing is, people need to realize that may be the contract, but that doesn't mean you have to sign it and agree to 100% of it. You're meant to look at that contract, read that contract. If there's some things in there that don't work for you, you need to go back to the customer and say, hey, this line here, that doesn't work for us. And have a conversation, because a contract is negotiable. So any lawyer will tell you, yeah, you know what? The contract, as it's written, is how it's enforced. But if you change the wording of the contract, and particularly in a particular clause, and you both agree on that wording, then that's what it'll stand by.
How likely is it that if I went to a major shipper and said, hey, this line here doesn't work for me, how likely is it that they are going to change the contract, especially when, you know, I'm probably one of 100 carriers that they might be using?
So that's where that's going to come into play. How desperate are they for your services? If you're one of 100, they're going to go, you know what, take it the way it is. We got 99 other guys over here we can use. So you want work from us, you will work under our terms and conditions.
Right.
So that's one of the dilemmas that you run into. Now, if you are one of 2 carriers for a small operation and they're quite busy and they need help, that's where you can kind of put a little bit of pressure on and go, guys, you know what, this isn't right. We got to do this properly. We got to protect both sides. So not only the carrier, but the customer. So let's agree on something we can both agree on.
Let me ask you a question. And again, it may be common knowledge out there for some people, but I'm basically, most of my trucking experience was as a safety guy. How does all of this, the bill of lading and the contract of carriage and all this stuff, how does this work with load brokers? Okay, well, I didn't mean it to be funny.
So the freight broker, the load broker, is really not in the relationship at this time when it comes to a bill of lading, because he's the middleman, but he's not carrying the cargo. He is not responsible for that cargo whatsoever. He's responsible for putting the relationship together between the shipper or the customer and the carrier, right? So the bill of lading, the contract of carriage, is between those 2 entities, okay? Now, with that said, there are many times a freight broker will have an agreement with their customer, okay? And you have to be very, very careful, because if you're hauling freight for the freight broker and the freight broker has an agreement with the customer, you are subject to that agreement between the freight broker and the customer. So you have to be very careful there. You need to understand what's going on. So one of the challenges of that is knowing if there's an agreement in place, and if there's not, you need to put a secondary agreement in place. Now, whether that agreement will be with you and the freight broker as to what your terms are for hauling this load, or you raise your own bill of lading from the shipper to the consignee on your own, and you cut out the shipper issued bill of lading. So, and that's where you run into that, because the other problem is too, you need to make sure that the freight broker's name is not on the bill of lading, because they're not the ones hauling the cargo. You are. I have actually seen guys charged with theft because their name was not on the bill of lading. It was a freight broker. Freight broker doesn't even have trucks, but the problem was it was listed as a freight broker having it. So that caused a bit of a dilemma.
Well, and there's a whole issue, just changing subjects a little bit. There was a theft over in, I believe it was Montreal, where trucking companies were picking up freight from a load broker, through a load broker, and then they were being told, oh, don't deliver it to the address on the bill of lading, we have to change it. And they all delivered, it was several loads to an empty warehouse where it was offloaded quite quickly. And it turned out that the warehouse was up for lease.
Yep.
So this was on Friday and Saturday, and by the time the loads that were supposed to be delivered on Monday were discovered missing, where the police went to the warehouse, and there's the sign had been knocked down that said for lease, and all the truck drivers said it was a great place to go. They offloaded me in like 20 minutes.
Oh, it was lots of room. They served me coffee. It was great. I want to go back.
But anyway, bills of lading is what we're talking about, not cargo theft.
Yeah,
But that's where it's very difficult when somebody says, hey, don't deliver it to the bill of lading, deliver it to this address instead.
Right. So that becomes another issue, because that becomes what you call blind shipment, right? So the problem is you need to raise a bill of lading. So you have to have another bill of lading that says I picked it up here and I'm delivering it here, which is different than the other bill of lading, which said, oh, deliver it over there, but now you're going to be reverted over here. So you have to raise another bill of lading. So, and sometimes that's because not a freight broker, but it could be a distributor who's bought the product and sold the product to somebody else. He doesn't want the end buyer knowing where it actually came from. He wants it to look like it came from him. So when you get into those, you need to make sure you have your agreement tightened up, knowing exactly what all the particulars are and knowing that everybody's protected.
Holy smokes, these truck drivers today need to take a course on the law and bills of lading. So.
Yeah. Well, again, it comes back to the responsibility of the carrier, right? The carrier is supposed to know these regulations, know what's required. Highway traffic acts in every province across the country all have these bill of lading regulations and whatnot. So if you're going to operate on the highway, you need to know. And then you need to educate the drivers and teach and coach them as to what they need to understand when it comes to handling cargo and cargo documentation.
So bills of lading should be part of a new hire orientation.
Oh, very much so. Very much so. So now, do you want to confuse the subject again?
Okay, let's make it even more confusing. Go ahead.
Okay, so we talked about declared values or limitations of liability, the $2 per pound quote. Okay, that works great in Canada, through Canada, back and forth across Canada, in and out of Canada, going to the US. That works great. But now we happen to be in the US. And now we're picking up a load in the US that's coming back to Canada. Well, now we have what's called the Carmack Amendment, which is a US regulation. And the Carmack Amendment says you can't limit your liability. So you can't put on the bill of lading $2 per pound. We're good. We're covered. No problem at all. You can't do it. It's illegal. What you have to do is have an agreement with the customer that you are going to you're going to haul the freight of X value, and I'm going to haul it for X dollars worth of freight rate. So you have to stipulate that. So obviously, this is where it helps that if the value of the cargo is $300,000, well, then I should get more freight rate because I'm taking on more risk, right? So if the shipper, let's use an example. Okay, so Cincinnati, Ohio, got a load coming back, and it's a load of widgets, and they're paying $1,000 to bring it back to Toronto, but it's worth $500,000, right? It's the gold-plated widgets. So anyway, so all of a sudden you're going, geez, $500,000, $1,000 is not enough money. No, exactly, it's not. So you might go, well, hang on, Mr. Customer. Based on Carmack, I need to limit the liability, but I can't limit it by just saying $2 per pound. We have to come to an agreement. So if you want me to haul it for $1,000, I'm going to give you $150,000 worth of coverage. That's it. And if they go, no, we got to have at least $250,000 worth of coverage. Okay, well, $250,000 worth of coverage. We're now looking at $2,000 to haul the load. And you have to put this in writing, could be an email, fax confirmation or whatever, but it's basically stating how much you're going to haul the load for and how much the load is going to be covered for. And then on top of that, you need to make sure that you have the coverage to back it. So again, if you've got the coverage of $350,000 from your insurer, then you're good to go. So, but too many people don't know this. So when you pick up a load that's worth $250,000 and you're doing it for $1.50 a mile, and you're thinking, God, this really don't pay much. well, you're on the hook for $250,000. You roll that over, you're now in trouble. Now, it changes and gets really confusing a little bit when we start talking about, well, who are you doing the load for? If you're doing it for a Canadian entity, you can limit to $2 per pound. So I'm picking up in Ohio, I'm bringing it back to Ontario, I'm doing it for the customer in Canada, which is very common with north-south operations. So now you can limit to $2 per pound because the agreement started in Ontario, right? Between me and the customer in Ontario, there's where the agreement started. Because we're picking it up in the US, we don't have to comply with Carmack. But if I happen to have the US entity as the customer and they're calling me up going, hey, we have this load every week, I fall under Carmack. So therefore, I can't limit it to $2 per pound. And you definitely can't rely on the pro forma or commercial invoice for customs because, again, that's not the true value of the product. So you need to have the conversation with the customer or a written agreement in place that says anytime I haul for you, we're going to haul it for $1,000. It's going to be worth no more than $100,000. And as long as everybody agrees, in the event something happens, we share that with the insurance provider and the claim will be covered up to $100,000.
You see, I'm confused.
Oh, I don't blame you. I'm confused too at times.
Well, you know, it highlights for me how confusing this all is, because really I've had no exposure to it before. I've never owned a trucking company. I've never had to worry about it when I was in operations. It was for one customer and one customer only, and somebody else within my organization had approved how we work for that customer, you know. So I'm really hearing a lot of this for the very first time. My insurance background says I know it's been a problem and it ends up in court a lot over the confusion because the carrier's saying that's not what I agreed to, and the shipper says here it is in writing, it is what you agreed to.
Yes, exactly.
So I know from that perspective, but I've really, other than like really what you're saying to me today, is probably the second time I've really discussed bills of lading. The first time was a lawyer that I heard from the States talking about bills of lading. Hank Seaton was his name.
Yes, and heard him, yep.
Actually, he's got a book out, and it's probably still relevant today. I know I've got a copy of it somewhere on my bookshelf, and I tried to read it, you know, but the subject matter was a little dry. And Hank did a great job.
Yeah, there's a lot of legalese in there, yes.
You know,
yes, so yeah. Well, and the trick is, if you're going to consult with legal counsel, you need to seek specialized legal counsel. Not every lawyer is going to know this. You want to talk to a transportation lawyer or law firm that knows contracts of carriage, regulations with transportation. And there are a couple of great ones out there. Fernandez and Hearn is one. There's one in BC. Oh my gosh, I'm sorry, the name eludes me right now. But there are a couple of really, really good transportation lawyers out there that understand this. And that's been one of my great things is I've gone to some symposiums where these people have spoken and some conferences. And this is where you can really get educated and then carry on that conversation even further with these folks to be able to say, I need to know more, you know. So in the meantime, to help protect most carriers, so those that are listening on the carrier side and operations, the one thing I encourage every customer I meet to do is that terms and conditions that I showed on the back of that bill of lading. If you have a set terms and conditions, post it on your website. Get it on your website, okay? And then put a link in your email signatures. All your staff in the office, put an email link in there to that website page. And I encourage people to be able to click on that link and say cargo valuation or cargo terms and conditions, and then have them, that way whoever sees it goes right to that page. And also have with that page something that says, unless a declared value is provided, Limit of liability is $2 per pound or $4.41 per kilogram. And I get people to put this on their load confirmation. So a lot of times you're getting a load from a freight broker or a customer, and they're requesting that you sign it, send it back, or email acknowledge. No problem. Acknowledge back and make sure this statement is on there that in lieu of a declared value, we're $2 per pound. Simple as that. It's not going to cause chaos. What it's going to do is if you haven't had a chance to talk to that customer yet and they see that on that confirmation or that notification, they're going to pick up the phone and go, Chris, what the heck are you talking about? What do you mean this $2 per hour? We've never had this conversation before. What are you talking about? My stuff's worth 40 grand. What are you doing? What are you doing? That's where you can sit there and talk and go, okay, Harry, no problem. Your product weighs 40,000 pounds. And what is the value? Oh, it's worth $40,000. Okay, you're under the $2 per pound. You're okay. We've got insurance coverage for you. And we now know truly what your product is worth. But when you get that load of golden widgets that comes up at 500,000 and it weighs in at 10,000 pounds, if there's no value, the insurance company is going to give you $2 per pound based on the jurisdiction. So, and anyway. But yeah, this is the problem with this subject. It is so like a spider web. It just goes everywhere, and it can be so confusing. But it doesn't have to be if you look within your own organization and understand, what are we doing? What are we hauling? Have we had talks with our customers? Do we have contracts in place? Do we have agreements with our shippers and receivers? And making sure that you understand what they are. And review those bills of ladings. So when a driver comes back and the shipment's done, you've invoiced it and closed it off, don't just attach the bill of lading to the invoice and file it away. No, let's have a look at that bill of lading and make sure there's nothing on it, that there's enough on it, there's good information, make sure everything's covered off, because if there's a claim, they're coming back and the only recourse you got is that bill of lading.
Right, so I really liked your suggestion there about the website, putting your terms and conditions on the website, and then having everybody that is conversing with the customers have it as part of their email signature.
Yeah.
So, and I've heard that before. I think Hank Seaton actually suggested that many years ago.
Yep.
And when I was working for the insurance company, I suggested it to many carriers, and I don't know of one that actually did it.
Yeah, that's the challenging part. I'm seeing more and more now when I have conversations with clients, and particularly over the last 5 to 10 years with the insurance side here, in having conversations, I've seen a lot of customers that we were working with have populated that on their website. Pat them on the back; they've done a great job. But you've got to be aware of it, and so to add to that too, you also need to be aware of any contracts that you're signing. So to add to insult to injury here, there should be one person in your organization that signs those contracts, nobody else. And that person should know every contract you have signed. Seen it too many times, gone into the organization, done an evaluation, and find out if you've signed any. Oh no, I haven't. I've signed one in the last. And then you happen to talk to a dispatcher operations. Oh God, I got a drawer full of them. I sign them all the time. Nobody knew this dispatcher was signing them, and then you start pulling them out and you're finding out that you're liable for the full value of the cargo, plus taxes, plus lost this, plus that. It's like, just signed away the company here. So that's why it pays to have one person in the organization who understands contractual agreements to be reviewing that contract and signing. I'll give you a great example of a customer I went to visit. They'd signed a contract, a logistics contract, for some big machinery. And what was interesting was, I asked if I could review the contract quickly, and he said, "Oh yeah, here you go. It's right here. I just finished signing it, send it back to them and whatnot. We've been hauling freight with these guys already for about a month." Perfect. In the contract, it stipulated that the carrier would be responsible for the value of the cargo up to $2 per pound. So I'm thinking, okay, cool. I read on another page or two. It now says that they're responsible for the full value of the cargo. Oh, that's interesting. That just supersedes that. And then we read a little further, and it says that they are enacting Carmack in the agreement. Well, the interesting thing is, it was a Canadian logistics company contracting with a Canadian carrier. You cannot enact a U.S. regulation on Canadian soil. So here we had 3 different scenarios of cargo valuation. And I said, what's the true value of the cargo? He said, Cripes, these things are worth like $3 million a piece. And I said, you might want to have a talk with somebody to find out. So he called him right there on the spot. And the guy says, oh, don't worry about it. It's just $2 per pound. Don't worry about it. I said, I would be asking for the new contract. And I said, that's where you should have been going through this contract and scratching out these lines, because I said, they're convoluting the whole situation by having 3 different scenarios. It should be one. What is it? One or the other. So, but that's where it's very important to read the contracts, know the customers you're dealing with, understand the values of the product that you're transporting. Don't just assume, oh, that's not worth much more than $1 a pound. Nah, So
it's crazy. And I think for more clarity, I would encourage customers to reach out to Mr. Farquhar, to Johnny Boy, and get some more information, because I'll tell you, this one conversation has stimulated a lot of thought, and I'm only a safety consultant. About
one of the things that we can do with a customer or client, we can help them. We can come in, we can review what it is they're hauling. Let's look at the cargo. Let's understand what it is. Let's look at some of the sample bills of lading that they're dealing with and help them to realize some of these don't have any values, and they also don't have a limitation. So now you're defaulting to the provincial law that you're operating in. But then, oh my God, this has been coming out of the U.S. This is for a U.S. customer. You got no value. You've been full risk here. So it's nip it in the bud now. Get a handle on it, because God forbid you have a huge claim that you're not responsible for. It's going to be a hell of a fight in court.
Yeah. John, in respect of your time, how about we wrap it up? What's
sure.
parting words, or anything that we didn't talk about yet that you really want to get out there today?
I think the biggest thing is probably just pay attention. Know what you need to know. And there's a lot of people that don't know what they don't know. Don't take it for granted that the shipper provided me a bill of lading, I'm okay. You're not. It's one-sided agreement from the shipping industry. So you need to be aware. So it's a matter of pay attention, get yourself educated, and review the bills of ladings that you're working with. Know what you got, know what you're doing, because sometimes you just need to have a conversation with a customer, because the customer doesn't know it either. As I mentioned before, when you're looking at jurisdictional situations, let's just use Ontario as an example, it's $2 per pound. If there's no declared value on the bill of lading, there's no limitation of liability, the courts are going to default to $2 per pound. And if you're telling me the product's worth $350,000 and it only weighs 10,000 pounds, the insurance company's only going to pay 20 grand. So somebody's on the hook. And who's that somebody? Probably going to be the carrier. So that's going to hurt.
So from this, I'm taking away several things. The website, the email address that you had suggested, and myself, I'd say call John for more clarification.
Yep,
and
be
his
happy to help out.
John's contact info is below in the show notes. All right, Johnny, that was
awesome.
I think that was a great interview, and I want to thank you so much for coming back on to talk about.
Well, thanks for having me. I appreciate it.
Bills of lading. And for our audience, if you haven't figured it out, John worked, God, what was it, 15 years, John, for an insurance company as a safety guy?
15 years for 2 different insurance companies, yep.
Yeah, okay, so a great deal of experience there. And then before that, you owned your own trucking company.
Yep.
And it wasn't even, where was it located, Brantford or just outside of Hamilton?
Just outside of Brantford, Paris, yeah. Ontario. Yep.
Okay.
And we ran all over North America, open deck, over dimensional freight and whatnot, all over North America.
Yeah, so you've got lots of trucking experience. You've got bill of lading experience. John is not a lawyer,
No.
but has a great deal more knowledge than I do when it comes to trucking and bills of lading. So awesome. Thanks, John, for coming on the Dawg on It Trucking Podcast.
Appreciate it, Chris. It was a hoot.
Okay. I hope you loved the show as much as I did. Please leave us a like, a thumbs up, a review, a comment, a rating if it is in your heart. Thank you so much. And I do really appreciate your time. And join us again next week for another exciting interview.